Did the Oklahoma Court of Appeals just kill motion to quash appeals? I told Attorney James Worth, and that's kind of the question that I'm dealing with right now. After a new decision from the Oklahoma Court of Criminal Appeals, it's a published decision, Halliburton v. State of Oklahoma, 2024 OKCR 7. And in that case, there is a defendant who was charged with the crime. Preliminary hearing was put on, as he's entitled to a preliminary hearing, and it was bound over by the magistrate judge, and then it went up to the district court. And in this case, the attorney for that defendant did not file a motion to quash, even though very clearly the state failed to establish one of the essential elements of the crime at the preliminary hearing. So let me give a little bit of background regarding preliminary hearings and motion to quash, and hopefully this will make a little bit more sense. So when someone is charged with a felony in the state of Oklahoma, pursuant to the Oklahoma Constitution, they're entitled to a preliminary hearing where the state has to demonstrate by evidence on the record in a hearing that there is probable cause to believe a crime was committed and that the defendant committed the crime. And we're looking at whether a crime was committed. We got to look at each of the elements of that crime defined by statute and show probable cause for each one of those. So, and then at that point, if the magistrate judge does find that there is sufficient evidence, then you're bound over for trial, and then it goes up to the district court judge on the path to trial. But you can't get to that stage without first the state demonstrating that there's probable cause for you to be bound over and have a trial. So you've got that right by Oklahoma statute and also by Oklahoma Constitution to that preliminary hearing. Okay, but in this case, ultimately that was put on, and the attorney did not file a motion to quash, even though very clearly the state failed to establish that key element. Ultimately, the case went on, the defendant was convicted, and then did this appeal alleging that his attorney was ineffective for not filing that motion to quash. Should have been filed, and it should have been granted because clearly, it's agreed by everybody in this case, the state failed to establish each of the elements. So the law has always been previously, going back to case law, we've got 1971, 1973, 1993, we have cases that clearly establish that if after preliminary hearing a case is kicked on a motion to quash, or at the preliminary hearing because the state failed to make their case, the state doesn't just get to refile unless they can establish that they have found new evidence, and that new evidence is evidence that they could not, or it's not reasonable to require them to have found previously. So they can't just refile if they lose a preliminary hearing. Oh, no big deal, we'll put on a hearing. If we screw it up, no problem, we'll just refile. We'll have the defendant rearrested, require him to rebond out, hire a different attorney or a new attorney for that case. They can't just keep doing this over and over. They can only refile if they establish that there is new evidence, and new evidence they could not have had before. There's actually case law on that I'd mentioned that goes back quite a ways. Here's the Chase case from 1973, and it's talking about, it's talking about a previous case of Jones from 1971. This says the Jones court held that a dismissal of the state's case at a preliminary examination bars a prosecuting attorney from refiling the case until certain evidentiary and procedural standards have been met. Those standards require the state to clearly show that it has acquired new evidence since the dismissal. We stated in that case, new or additional evidence does not mean that which was known to the state at the time of the first preliminary or that which could have been easily acquired by it. So before a refiling may be permitted, the charge must be brought before the same magistrate who originally dismissed the case, and consideration by another magistrate is forbidden unless the first be unavailable. So it's got to be new evidence that they didn't know about before and could not have easily acquired before. And under those circumstances, if that exists and they show that, then they can refile. So that's been the law forever. However, in this case, in trying to determine whether the person had ineffective assistance of counsel, the court looked at that it's not enough for it to be ineffective. They also have to show that there was prejudice. So they found a shortcut in determining whether there was prejudice or not by essentially reevaluating what the law has always been, and they're now interpreting a law that's been in place since 1990 and has never been interpreted this way before. But now they're saying that the state can refile a new case if it's dismissed at a preliminary hearing or on a motion to quash without there being any new evidence or anything at all, just no requirements whatsoever. They can just automatically refile. And because they can automatically refile under this new standard that they've just made up, there can never be prejudice. Therefore, there can't be a claim for ineffective assistance of counsel. So sure, the attorney should have filed a motion to quash. Sure, that motion to quash should have been granted. But now, because we're saying the state could have just refiled and fixed it anyway, there's no damages, there's no prejudice by that. Therefore, we're not going to grant your appeal based on ineffective assistance of counsel. So that's what happened in that case. But now I'm looking at what are the potential further consequences of that decision. If the state can automatically, for no reason at all, no new evidence, refile a case that's dismissed at preliminary hearing on a motion to quash. So we didn't make our case, no big deal, we'll just refile. If that's the case, then there's not really any reason why the state would appeal a granting of a motion to quash or appeal a decision by the magistrate at a preliminary hearing that there wasn't sufficient evidence. Because right now they can appeal those things, but why would they if they can just refile and trial again? And if we're getting away from that law that required it to be in front of a different judge or a different magistrate, well, maybe they can do a little forum shopping too. Well, this judge dismissed it, let me refile, maybe I can go to this judge. So it seems like the court may have gotten rid of any reason for the state to appeal a granting of a motion to quash, but what about the defendant? So typically, as in this case, although the attorney in this case did not file a motion to quash, if they had filed a motion to quash, the judge denied it and went on to trial and he was convicted. And now he appeals and said this should have been dismissed at the preliminary hearing, should have never gone to trial. Well, the courts typically not only look for abuse of discretion, but they also look at prejudice. I mean, what difference did this make in the case? And if it's the court's position that the state can always refile, and in this case, in every case, if it goes up on appeal, that means it went forward and there was a conviction. So obviously the state, was able to meet their burden by beyond a reasonable doubt. They just couldn't make it at the preliminary hearing for the much lower probable cause. So obviously they strengthened their case. So because the court's saying, well, they must have strengthened their case here, so we know they had enough. If they refiled the preliminary hearing, they probably could have gotten it bound over that way. Then seems like there's never going to be a circumstance where a defendant can ever prove prejudice. So by redefining what the law is on whether a state can refile, it seems like they've incidentally abolished appeals on motions to quash, since there's no incentive for the state to file one, and now the defendant can never prove any prejudice. I guess that right is just gone. And if you can never appeal a decision on a bind over by the magistrate at a preliminary hearing or on a motion to quash, then there's not really much of incentive for judges to make sure they get it right. Essentially, if the judge denies a motion to quash, well, there's no recourse for that, so nothing to worry about. If the judge grants a motion to quash, then the state can simply refile. If the judge denies one, then there's no recourse. So it seems like that another decision from the Oklahoma Court of Criminal Appeals, it's changing the law and kind of thinking about what the consequences for that are long-term in other situations, but it's another step taking away rights from the people, meaning the right to a preliminary hearing that's meaningful. It's not meaningful if the state can just refile and try, redo it again, maybe in front of a different magistrate. We'll just keep refiling until we get it right. And the defendant can just, keep paying bondsmen until we get it right. And the defense can just keep hiring attorneys until we get it right. Seems like that there's no recourse there. There's additional loss of rights by defendants. But if you're dealing with this circumstance, it's still something you've got to deal with. And you're going to want to talk to an attorney privately and confidentially about your circumstances to see what the best route is for you. To get an appointment scheduled with an attorney at my office, you can go online to makelaweasy.com.